Hello, and welcome to our presentation on reduced risk through commercial item contracting. My name is Erin Toomey. I am a partner at Foley and Lardner out of our Detroit, Michigan office, and I am a government contracts attorney. Today's program is going to run for 90 minutes, and we are going to apply for 1.5 general CLE credits. Anyone wishing to receive credit for today's program must enter the code when announced. A box to enter the code will appear on your screen for approximately 30 seconds. Everyone seeking CLE credit must enter the code in the box on their screen at that time. All New York, New Jersey, and Kansas attendees applying for CLE credit must also fill out an attorney affirmation form and write down the course code. The attorney affirmation form and a copy of today's slides can be obtained in the resource list widget at the bottom of your screen. For New York attorneys, those of you with less than 2 years of experience will not be eligible for CLE today. Completed attorney affirmation forms should be emailed to Christina Wade at cwade@foley.com. CLE certificates will be sent to eligible attendees via email in approximately 8 weeks. Questions can be submitted during this web conference by entering them in the Q&A widget, which is open on the left side of your screen. I will answer questions at the end as time permits, and potentially when we have some short breaks during the presentation. Keep in mind that if there are multiple people in the room, that all of you who are seeking CLE credit will need to ask for the CLE credit and fill out those forms. So let's get started. So today we are going to be talking about reduced risk through commercial item contracting. Commercial item contracting is a concept which I deal with often in my work, and a lot of my clients are commercial item contractors, and I am having trouble right now advancing the slide. So if someone can make sure that I can advance to the next slide, that would be great. Okay, there we go. Historically, there have been impediments to contracting with the federal government, and those are due to government-unique auditing and accounting requirements, such as the Cost Accounting Standards and the Truth in Negotiations Act. The government also has unique specifications and standards, especially when it comes to quality testing and inspection. And the government also gets certain rights in a contractor's technical data, computer software, and inventions that are developed with government funds. There are also government-unique contract requirements, whether it's a specification, the government can make unilateral changes to the contract, and all of those are things that we'll talk about today. Because of these historical impediments to contracting with the government, commercial companies were unwilling to do business with the government directly. And that had resulted in what we used to hear stories of, which was the $800 toilet seat. The things that a commercial company or individual could go to Home Depot and get for a certain price, yet they were paying extraordinary amounts for it at the government because only certain companies were willing to comply with these onerous requirements and do business with the government. In October 1994, the government enacted the Federal Acquisition Streamlining Act, and this dramatically changed the government's procurement philosophy. A key provision in FASA is the government's stated preference for the purchase of commercial items for many reasons. First, the purchase of commercial items is going to reduce the need for government-funded research and development. It's going to minimize acquisition lead time because the government could purchase goods and services that are readily available, and reduce the time needed for detailed design specifications and expensive product testing. In all, this would also reduce costs. Basically what happened is the government had done a study as to what were the significant cost drivers driving up the cost of government products versus commercial products, and they found that these were significant cost drivers. So FASA encouraged government agencies to ensure that their requirements are defined so that commercial items can be procured to fulfill agency requirements. If there is a commercial item that's available, the government won't need their heavily government-specified product. As a result of FASA, in 1995, the Federal Acquisition Regulation, which governs the federal government's procurement of goods and services, the FAR Council implemented FASA by revising FAR Part 12 to include certain policies and procedures that are only applicable to commercial items and create acquisition policies that more closely resemble the commercial marketplace. So for things where the government was fairly unique in their contracting practices, where they're imposing onerous requirements, FAR Part 12 identified those laws and regulations from which commercial item contracts would be exempt. Among other things, FAR Part 12 also requires government agencies to conduct market research. So when the federal agency is determining what it is they need and what they're looking to buy, they need to determine market research and see if there are commercial items available to satisfy their requirements. If there are commercial items available, they're required to buy them. And also, prime contractors and subcontractors at all tiers in the supply chain are encouraged to the maximum extent practicable to incorporate commercial items as components of items that are supplied to the government. The government's stated preference to acquire commercial items includes both commercial item goods and services. As noted here, in fiscal year 2014, the Department of Defense acquired over $60 million worth of goods and services as commercial items. Commercial item contracts are streamlined to more closely resemble non-government commercial contracts. So what does this mean? They have a significant number fewer of FAR and DFAR and other clauses and flow-downs. There also is a clause we'll talk about a little later that contains the basic terms and conditions of the contract with provisions such as inspection, acceptance, warranty, termination, and those terms more closely resemble the commercial marketplace. Importantly, FAR Part 12, talking about commercial item procurements, takes precedence over any other section of the FAR. There was actually a recent case this year where it held that FAR Part 12 took precedence over FAR Part 8, which we'll talk about a little later, which is Federal Supply Schedule Contracts. But that's important because it's giving support to the notion that even if there's another part of the FAR that says a certain provision applies to contractors, but FAR Part 12 says commercial item contractors are exempt from that requirement, FAR Part 12 will take precedence. So what are the benefits of commercial item contracts? Why are we talking about this? Why do we care? Well, for contractors, as we've noted, there's a significant reduction in the requirements that apply to commercial item contractors. With respect to the government and higher tier contractors, what it does is it keeps costs lower and it reduces the administrative burden, which results in less risk. So that helps contractors keep their prices competitive and benefits the government. It's less audit, it's less oversight, and even for higher tier contractors, that results in less risk. Well, what is a commercial item? Commercial item is found in FAR 2.101, and it has an 8-paragraph definition. All 8 paragraphs are in these slides. We're not going to talk about all 8 of them. I'm just going to focus on a few of them. The most important paragraph is the first one, which relates to commercial item goods. As I mentioned, you can have commercial item goods and commercial item services. And of these 8 paragraphs in the FAR, different paragraphs deal with goods versus services. But this first paragraph 1, a commercial item is any item other than real property that is of a type customarily used by the general public or by non-governmental entities for purposes other than governmental purposes and has been sold, leased, or licensed to the general public or has been offered for sale, lease, or license to the general public. Let's break it down. Of a type. It does not have to be the exact same good that you sell commercially that you sell to the government. It just needs to be of a type. Well, how do you define of a type? It's not defined in the FAR. It's not defined in cases. And as we'll go through in a minute, the government has really had some heartburn here because it is so broad and so vague, contractors have taken advantage of it. And there have even been some parts of weapon systems that have been procured as commercial items that has subject Department of Defense to some scrutiny. So of a type, for the contractor's benefit, it is very broad. It is vague terminology. Really where the government has focused is what is the primary function of that part? What are the key physical characteristics? So when I'm helping clients put together a commercial item justification or determine is this a commercial item, we really look at what does the part do? What is its application? What's its primary purpose? What are its major components? What are the materials? Things of that nature. In terms of customarily used by the general public or by non-governmental entities for purposes other than governmental purposes, what does that mean? It means if you are selling to a higher tier contractor, such as the BAEs, Oshkosh, Boeings, Lockheeds of the world, it is not enough to say that that's a commercial customer and that is a sale to the general public if it is ultimately for a government purpose, if it's for a government program. So what you need to look at is your purely commercial applications. Is the sale that you're selling to that commercial customer ultimately for a commercial application? So let's take a starter motor for a heavy-duty commercial vehicle and one for a military vehicle. If it has the same primary function, same primary purpose, same key components, that is the type of thing that we look for. The other parts of the definition has been sold, leased, or licensed to the general public. So it doesn't mean that you yourself as a company has to have sold it or leased it or licensed it. Somebody has had to sold or leased or licensed. And again, it's just an of a type product. So somebody out there has had to have sold something similar. And then the second one has been offered for sale, lease, or license to the general public. It's even better because that's an or. It doesn't even have to be that someone out there has actually sold it to the general public. It's that someone out there has offered something similar for sale to the general public. And hearing how broad this definition can get, you could see why the Department of Defense has had some concerns about it in recent years. I'm going to skip through a few slides here and go to the third paragraph, because if you don't quite fit in that definition, you might fit in this one. And again, this is a good definition in paragraph 3, and it's any item that would satisfy a criteria expressed in paragraph 1 of the definition that we just talked about, but for a modification of a type customarily available in the commercial marketplace, or a minor modification of a type not customarily available in the commercial marketplace made to meet federal government requirements. And then there's some elaboration on a minor modification. So this is if you have a certain component, but maybe for government purposes, you have to make it a little bit more robust. Maybe there's some bulletproofing or explosion proofing aspects to it. If those, though, are minor modification, and sometimes we'll use a cost litmus. So maybe if that additional aspect of it is maybe less than 5% of the total cost, that might then be a minor modification that would fit within this definition here. Moving along, I'm going to move along to the services definitions, and there's two primary ones to talk about. The first one is paragraph 5, and this says that installation services, maintenance services, repair services, and training services, and other services are a commercial item if they're procured in support of a commercial item, regardless of whether the services are provided by the same source or at the same time as the item. So you could be selling the government a commercial item and then later enter into another contract with the government to install that product at a government facility, and that installation contract would still constitute a commercial item service. And then the second piece, and again there's an and here, the source of the services provides similar services contemporaneously to the general public under terms and conditions similar to those offered to the federal government. So this needs to be the type of service that is routinely offered to the general public in connection with those commercial items. If you notice in that definition, in that paragraph 5, there is specific types of services listed. This paragraph 6 is a more general definition, and to the extent your company is a consulting company, advertising company, providing some other types of services that are not tied to a good, such as installation, maintenance, repair, this is a paragraph that you would need to fall in. This definition says services, again, we have the of a type language, offered and sold competitively in substantial quantities in the commercial marketplace based on established catalog or market prices for specific tasks performed or specific outcomes to be achieved and under standard commercial terms and conditions. A few things here. This adds in the substantial quantities language. What is substantial quantities when you're talking about a service? Well, it's not really clear. But what's more important is that when we're talking about a commercial item good, the determination of whether or not it was a commercial item was completely independent of the price of the item. Here for a commercial item service, in order for the service to qualify as a commercial item, you also have to show that the pricing is based on established catalog or market prices. The next slide, I have the definition in the FAR of what is a catalog price and what's a market price. And the catalog price, do you have an established catalog price list schedule that's regularly maintained? Doesn't mean that it has to be publicly available on your website. I mean, it's something that you distribute to your customers, but it doesn't have to be something that's published. And then the market prices. What are those prices that are established in the course of ordinary trade between buyers and sellers? And then the next few parts of the definition I'm going to skip over. So that's a commercial item. A lot of times when I'm working with clients, they'll say, well, no, what we're selling to the government, it's really government unique because we build it to government specifications and it's not identical to what we sell commercially. And I said it doesn't have to be identical. It's just that of a type language. And what they are often thinking about is the COTS concept, commercially available off-the-shelf item. Although a COTS item is a commercial item, you can have a commercial item that is not COTS. So if you have a Venn diagram there, the COTS is the overlap between commercial item. It's part of it. It's a subset of a commercial item, but you don't have to have it be COTS to be a commercial item. What is a COTS item? It's a commercial item. So first you have to meet that definition in paragraph 1 of the commercial item definition. It's sold in substantial quantities in the commercial marketplace, and it's offered to the government under a prime contract or subcontract at any tier without modification in the same form in which it is sold in the commercial marketplace. So this is the identical item. There's no changes. It's the exact thing that you sell commercially. There are additional clauses that COTS contracts are exempt from that still apply to commercial items. So there is an additional benefit in getting your product classified as a COTS item. And keep in mind, COTS only applies to goods, not services. So as I mentioned, you can drive a bus through the commercial item definition, and contractors have been doing it for years, and Department of Defense has gotten frustrated with that. So in 2012, the Department of Defense proposed a statutory change to the commercial item definition, and they wanted that included in the National Defense Authorization Bill for fiscal year 2013. What they wanted to do was eliminate the of a type language and also eliminate being able to qualify as a commercial item if you have merely offered for sale, lease, or license, but have not actually sold, leased, or licensed the product to the general public, and they wanted to take that out of the definition. They also wanted to adjust the standard for determining whether a price is fair and reasonable, to require the prior sale of substantial quantities, and to change it to like quantities. Again, it's really restricting what could qualify as a commercial item. Importantly, this proposal was not eventually included in the House or Senate versions of that bill, but DOD did not stop there. In 2012, they issued a final rule, which means it is in effect, that requires a higher level of approval for commercial item determinations when the acquisition is over $1 million and the determination is based on that of a type or offered for sale language in the definition of a commercial item. However, good news for contractors. For those of you who are there, I did this presentation in October in person here in Livonia, Michigan, and I didn't have this good news then, but I have it now. The pendulum seems to be shifting. In the fiscal year 2016 National Defense Authorization Act, there are several sections that we'll talk about today that are favorable to commercial item contractors. Again, the National Defense Authorization Act, it only applies to Department of Defense contractors, but that is the area where we saw the most restrictions on commercial items seeming to come into play. Section 851, relating to the procurement of commercial items, requires the Secretary of Defense to establish and maintain a centralized resource for commercial item determinations. Previously, when the government makes a determination, a good or service commercial item, there's nothing that's published. There's nothing you can get your hands on unless potentially you seek documentation through the Freedom of Information Act. This is going to give you public access to those determinations. So it's going to give you a chance to see what are other contractors doing? What has the government previously accepted as a commercial item? It also allows contracting officers to presume that a prior Department of Defense commercial item determination serves as a determination for subsequent procurements of such items. So if you already have sold something to the DOD and it's a commercial item, that determination holds. It also, in my opinion, should hold throughout the supply chain. So if you have the government who's purchased your good as a commercial item and now you're selling it to a higher tiered contractor, they should be able to rely on that determination as well from the government, and you shouldn't have to go through the whole drawn-out commercial item determination process with that customer. To depart from this commercial item precedent, the contracting officer needs to request a review by the head of the contracting agency, and that determination must be made within 30 days. So this whole process and the purpose of this section is to expedite what has traditionally been a time-consuming process of commercial item determinations. Those sometimes could take months or even years to make, and this is an intent to really streamline that process. In terms of the Section 855 of the NDAA relating to market research, really what this does is an effort to make sure that the government is doing the market research they need to do to determine if there are commercial items that satisfy their needs, and in particular in the areas of technology and logistics. So basically what this does is that it's asking for the Undersecretary for Defense of Acquisition, Technology, and Logistics to issue guidance that at a minimum prohibits the award of a contract in excess of the simplified acquisition threshold, which is currently $150,000, for IT products or services that are not commercial items, unless the head of the agency makes a written determination that no commercial items are suitable to meet the agency's needs. So again, this is a huge benefit to commercial item contractors, especially in the IT area, encouraging market research and not just doing the easier go-to government-specific specs, but really to determine if there's a commercial item out there that suits the agency's needs. Next is Section 856 of the NDAA, which is a limitation on the government's ability to convert a commercial item procurement to a non-commercial item procurement. So prior to making that conversion, if something traditionally has been purchased as a commercial item, if it's over $1 million, before they go to a non-commercial item procurement, the contracting officer must make a written determination that the earlier use of the commercial acquisition procedures was an error or is somehow based on inadequate information, and that the Department of Defense is going to realize a cost savings in going to a non-commercial item procurement under FAR Part 15. Further, if the acquisition is over $100 million, there needs to be approval by the head of the contracting agency. And so this is really, again, beneficial to contractors. We do see sometimes, especially when it comes to the procurement of services or certain goods, the government does flip-flop back and forth, between a commercial item, non-commercial item, even for the same goods or services across departments and agencies. We might see the Army procuring something on a non-commercial item basis while the Navy's procuring it on a commercial item basis, but it's really the same good or service. This will help streamline those processes so the right hand knows what the left hand's doing, and there's, in the end, it's going to reduce administrative time for the government and benefit commercial item contractors. The next is Section 857, treatment of goods and services provided by non-traditional defense contractors as commercial items. And this authorizes the Department of Defense to treat certain items and services that are provided by non-traditional defense contractors as commercial items. And the definition of a non-traditional defense contractor is a company that has not performed in the one-year period prior to the DoD solicitation a DoD prime contractor contract subject to the cost accounting standards. Prior to this revision, it also included, the definition included a contractor that you could not be a non-traditional defense contractor if you had performed a contract in the prior year with DoD where you had to provide certified cost or pricing data. As many of you folks know, the standards for CAS are more onerous than cost or pricing data, and you may be subject to cost or pricing data, but not CAS. So this is going to open up a whole host of new companies that would be considered non-traditional defense contractors. In terms of coming back to commercial item contracting, some things to keep in mind: those contracts need to be done on a fixed price basis or fixed price with economic price adjustment. If it's fixed price with economic price adjustment, the price adjustment must be based on fluctuating labor or material costs, but it needs to be on some sort of independent indices, so it can't just be based on your actual cost experience. In a fixed price contract, the government agrees to pay a certain price for the product or service at the time of the award, and the contractor bears the risk of any excess performance costs. These give the contractor the greatest profit opportunity if they can manage their costs, but also has the greatest risk if you have a cost overrun that's going to eat into your profit. There are some exceptions for labor hour and time and material contracts that require various high-level government approvals, but the key here is you may not have a cost reimbursement, whether it's cost plus fixed fee, cost plus award fee. You cannot have that type of a contract and have it be a commercial item contract. You can have a commercial item subcontract even if the prime contract or higher tier contract is non-commercial. And this is very important because oftentimes on behalf of clients we'll be trying to negotiate a subcontract that we think is a commercial item, and the customer says, well, my contract's not a commercial item, so yours can't be commercial item. And we say, well, no, that's not the case. And not only is that not the case, but we know if your prime contract's non-commercial, you have in it FAR Clause 52.244-6. And what that clause says is that the contractor must incorporate at all tiers, to the maximum extent practical, commercial items as components of items delivered to the government. So not only does it not say that you can do it, and it says that you should do it. So that is the justification for you subcontractors out there when you get pushback from your prime or your customer about trying to get commercial item treatment. This is what a commercial item prime contract looks like from the government. You can see the information up here in the top block. It says solicitation contract offer for commercial items. Some people come to me and say, how can I tell if the solicitation is a commercial item or the contract's a commercial item? It's on this form. That's how you can tell. Some agencies don't use that form, like the Defense Logistics Agency. They may not use it. So some of the triggers to look for in those types of orders are to look for these clauses here. If you have these clauses in your contract, then it is a commercial item. And you can see what I have is a snippet here that is the bottom of the form that I had on the previous slide. And you can see for solicitation, the box 27A is checked to say it's a solicitation that contains certain clauses in the FAR. And then 27B is checked once it becomes a contract. What are these clauses? Well, the first one I want to talk about is FAR 52212-4. And that is the one I mentioned earlier, that is, this is what includes those terms and conditions that you would typically see in a purchase order with a commercial customer. Inspection, acceptance, assignment changes, so on and so forth on this slide. What is very important is typically FAR clauses are non-negotiable. You can negotiate whether they're in or they're out depending on whether or not they should apply to your contract, potentially. But you cannot modify them. You can't go in and redline the clauses with the government. Don't try it. It doesn't really go over very well. What you can do, however, is this is the only clause that allows you to tailor certain provisions of it. So those paragraphs that are in bold and underlined on the slide cannot be tailored. You cannot change them. The government won't allow it. However, the FAR specifically says that all of those other provisions can be tailored to the extent that you propose that how you are tailoring it is consistent with commercial practices in your industry. Let me give you an example. Paragraph O of that clause is the warranty language. The warranty language is short. It says the contractor warrants and implies that the items delivered hereunder are marketable and fit for use for the particular purpose described in this contract. All of those who do contracting will recognize those as the standard implied warranties under Article 2 of the Uniform Commercial Code. First of all, only applies to the sale of goods. So what happens if you're providing services? Doesn't really make sense. Also, these are the exact warranties that commercial companies often want to expressly disclaim. They don't want these to apply in favor of having some form of an express warranty. So this is one of those things when you have a commercial item contract, you should probably propose to the government a different warranty, whatever warranty is standard in your industry, to replace these implied warranties here. In terms of a recent update, GSA has been, ever since July 2015, has been thinking about doing a new rule, and they actually then issued a deviation, and now it's a proposed rule. But basically what's been happening is GSA has a lot of contractors that are providing IT services, computer software, things of that nature. And a lot of, under FAR Part 12, commercial item contractors can propose their own standard license agreement, which is one of the benefits of commercial item contracting. Well, if you ask a software company for their standard user license agreement or somehow their standard license agreement, there's a lot of provisions in there that actually the government cannot accept. And so the GSA has gone through and said, here's a new clause in the GSA acquisition manual, and that these basically provisions here are going to take precedence over any conflicting provisions in the contractor's standard terms and conditions. So for example, laws and disputes. A lot of folks have out there, well, it's a law that governs this agreement is going to be whatever state that they're located in. Well, the federal government cannot agree to be governed by state law. They're governed by federal law. Also, indemnification. The government actually cannot indemnify contractors unless they have express statutory approval, because they are something called authorization acts, and the government, it's an Anti-Deficiency Act violation for the government to obligate funds that they don't have. So it's an indemnification issue. So you could read through these at your leisure, but this is a proposed rule, and so we should probably be expecting shortly a interim or final rule coming from GSA on this topic. The other FAR clause is 52212-5 that's in commercial item prime contracts. This is a check-the-box format. There's a bunch of other FAR clauses that are referenced here, and the contracting officer needs to check off which of those FAR clauses apply to this specific procurement. Also for commercial item prime contract, you'll see it includes the DFAR clause 212.301, which refers back to the DFAR clauses I'm sorry, you won't see a clause. There used to be a DFAR clause. Now it's just in the policy language that lists the clauses that do and do not apply to commercial item contracts. So what are your best practices for a commercial item prime contract? Review the government's clauses. What's negotiable, what's not. Don't waste your time in trying to redline FAR clauses or negotiate out mandatory clauses that cannot be tailored. Identify the clauses you want to tailor and provide a justification to the contracting officer, and you'll have to justify those as customary commercial practice. For FAR 52-212-5, make sure that the clauses the contracting officer has checked off actually do apply. If you're selling goods to the government and they've checked off the Service Contract Act clause, it doesn't make sense, and you should ask for that to be unchecked. Commercial item subcontracts. So those are a hybrid of a commercial item prime contract with FAR clauses, DFAR clauses, other agency supplemental clauses, and a commercial contract that's governed by Uniform Commercial Code and other commercial and statutory law. Typically with commercial item subcontracts, the FAR clauses and other laws, rules, and regulations don't apply unless they're expressly incorporated into the agreement. For those of you who are familiar with the Christian doctrine, it's basically a doctrine that says that certain clauses that are fundamental to government contracting are read into a contract even if they're not actually in the contract. That has only been held to apply at the prime contract level. So although there are some clauses where if they're not in your prime contract, if they're held to be fundamental to government contracting, like the termination for convenience clause, it will be read into your contract. However, again, that hasn't been applied at the subcontract level until March of 2013. In that case, in UPMC Braddock, there was a reference to the Christian doctrine in reading into a subcontract the equal employment opportunity clauses. This is a unique scenario in my mind, though, and I don't think this is going to have broader application outside the equal employment opportunity context. The equal employment opportunity clauses are based on regulations that themselves say they apply to certain subcontracts even if the clause or the language or the regulation is not expressly stated in the contract. Because that is in the regulation, that was really all the basis that that court needed to hold that it's read into the contract. They went a little bit further in reference to Christian doctrine, but again, I don't think it's really held. So it's important to know for your subcontracts, if it's in there, you could be held to comply with it, even if technically it shouldn't apply to you. And vice versa, if it's left out, you have an argument that it doesn't apply. As I mentioned, it's also, subcontracts are also governed by commercial law. The Uniform Commercial Code, Article 2, only applies to the sale of goods, so other statutory laws and common law will apply to the sale of services. And reading, it's important to have knowledge of what the FAR clauses are to read them harmoniously with what the commercial terms and conditions are that are getting flowed down to you from your customer. If the prime contract is not a commercial item contract, then as I mentioned earlier, it's going to contain clause FAR 52.244-6. And not only does that clause say incorporate commercial items in what you sell to the government in lower tiered contracts as much as possible, but it also identifies those FAR clauses that must be flow down to commercial item contractors. And it does say that that's basically it. It's really a small subset. However, one of the paragraphs then says the prime contractor can flow down to subcontracts for commercial items a minimal number of additional clauses necessary to satisfy their contractual obligations. Well, what does that mean? Well, it means that some customers then flow down everything, and they say, this is all necessary for me to satisfy my contractual obligations. I don't really agree. I don't think that's the right approach. It's the easy way out from a quote-unquote lazy subcontracting standpoint, but it's not the right result. What are some of the things that you need to flow down? Well, let's take termination for convenience, for example. The government terminates you for convenience and says, you're done, stop working. If you don't have the ability to flow that down to your subcontractor, you're a business risk, right? Subcontractor might sue you for breach. All of a sudden, you're subject to breach damages. The government's not going to pay for those. However, the termination for convenience clause, it's not in that list in 52.244-6. It's also not a required flow down. It doesn't tell the prime contractor they have to flow that down. So there are some areas where, as a subcontractor, you could say, okay, it's not required, it's not on this list, but I get it, right? You're going to be at risk from a business perspective. So if the government terminates you for convenience, I'll accept it. And I included here some other examples of clauses that are not in that list, but from a reasonable negotiation standpoint, technically I'll advise my clients to accept it. And from a customer standpoint, these are ones I say you need to also flow these down. Also, your prime contract, if it's a Department of Defense contract, will contain DFAR 252.244-7000. And again, this is what refers back to the policy language, which talks about the clauses that need a flow down. If the prime contract is a commercial item contract, then FAR 52.212-5 identifies the mandatory flow down clauses, and again has that same language that permits them to flow down a minimal number of additional clauses necessary to satisfy their contractual obligations. Interestingly enough, the lists in 244-6 and 212-5, they're not identical. There are a few clauses that are in the 244-6 that are in 212-5, vice versa. I'm not quite sure exactly why that is, but you'll have to know which environment you're in to know which clauses to flow down and negotiate. From a prime contractor perspective, and when I use the term here prime contractor, it's really the buyer, whether you're the prime or a higher tiered contractor. They usually have the most bargaining power. There are some clauses that must be flowed down or the prime contractor is going to be in breach. But keep in mind, not all provisions must be or even can be flowed down. And here are some examples where I get into arguments with on behalf of clients with their customers who just flow everything down. Let's talk about the electronic fund transfer provisions through the System for Award Management. That's the government system of how the government pays prime contractors. We all know that's not how the prime contractor is going to pay the subcontractor. Why is that provision getting flowed down? It just muddies the waters and gets confusing. How about the disputes clause? The disputes clause is very clear. It only applies to prime contractors. The Contracts Disputes Act, it's only a mechanism available to prime contractors. So if the FAR disputes clause is your disputes resolution mechanism in your subcontract, you effectively have none. Also, the subcontractors, it's usually a subset of the prime contract requirements. So maybe you might have a prime contract that is for the sale of goods, but what you are doing for them is a service. Maybe you're doing some inspection services or some testing services. You're doing a service. Well, it doesn't make sense for you to accept those clauses that apply to the sale of goods if you're providing a service and vice versa. Also, what about if the prime contractor has a cost type contract, let's say a cost plus fixed fee contract, and you as a subcontractor have a fixed price contract? Well, it does not make sense for the prime to flow down those cost type clauses to you. They should instead only flow down those that apply to fixed price contractors. And then again, there's other clauses. Well, again, they're not mandatory. The prime contractor should flow them down to protect their interests, changes, termination, stop work order, etc. From the subcontractor's perspective, they need to accept the clauses the prime must include to cover its legitimate risks. However, they also need to identify the clauses that are not mandatory flowdowns, that don't cover a prime contractor's legitimate risks, and that cause a burden on the subcontractor. Some of the clauses, even though they're not technical flowdowns, they sometimes don't really increase the contractor's risk to accept them. And that's a call that each contractor needs to make for themselves. But the challenge for the subcontractor is for those clauses that really increase their risk, they're burdensome, they're onerous, or just unfair, that they need to really put together their justification as to why they're pushing back on those inclusion of those clauses in their subcontract. Also, it's important for companies to think, okay, if I accept this clause, maybe it's not required, but I just want to get this deal done. Can I flow it down to my subcontractor if that's a requirement? Because that can sometimes be a concern as well. Is there a benefit for commercial items, subcontracts, and prime contracts? As I mentioned earlier, there's exempts from many laws and regulations. And here's a slide for you to reference where in the FAR and DFAR they list the various exemptions for prime contracts and subcontracts and COTS items. In terms of those clauses that do and do not apply to commercial item contracts, in recent years, especially in the area of Department of Defense, we've seen a significant increase in the number of clauses that apply to commercial item contractors. They're not really getting that benefit of the exemption that they once were. And Department of Defense is recognizing this. So this Section 854 requires the Department of Defense to submit to the Congressional Defense Committee a report that identifies defense unique provisions of law that are applicable to commercial item or COTS procurements at the prime contract and subcontract level, and really justify them. Why is it that they're included? Is it standard with commercial practices? Is it inconsistent with standard commercial practices? And they have to really justify that, which I think is really going to help contractors in the commercial item area to really push back on a lot of these new rules, which frankly it seems to be every single one that's issued applies equally to commercial item contractors and non-commercial item contractors. So what are some of the benefits? I'm going to breeze through these slides. If you're not familiar with these concepts, I think we could spend a whole day on each of them. But the first is what is formerly known as the Truth in Negotiations Act. We still refer to it as TINA, but technically its name was changed to Truthful Cost or Pricing Data. This is a requirement to provide the government with all significant and relevant cost or pricing data available to the contractor during price negotiations. It's a disclosure statute. Government wants to know all your cost information, your anticipated profit, everything that, of course, we would all love to know about from the company that we're buying from, but traditionally don't get to know. More importantly, though, the contractors should certify that everything they're giving is current, accurate, and complete. Again, it's a disclosure requirement, and the definition of cost or pricing data in the FAR is very broad. And so it requires you to disclose a significant amount of data to the government, and your failure to disclose certain information could potentially result in a later price reduction, or because you're signing the certificate, potential criminal or civil liability. So there's a lot of risk here, and if you're not a government contractor traditionally who has in place policies and procedures to comply with these requirements, you can really find yourself in some trouble. But commercial items are, and modifications to commercial item contracts are an exemption from the TINA requirements. Cost accounting standards. These govern the measurement, timing, and allocability of costs that are charged to certain negotiated government contracts and imposes major accounting requirements on contractors. Again, there's an exemption for fixed price and fixed price with economic price adjustment, time and material and labor hour contracts, and subcontracts for the acquisition of commercial items. Audit and records. So the government's ability to come back and audit your cost or pricing data. That doesn't apply if you are a commercial item contractor, except if you have a commercial item contract that's a time and material or labor hour contract, you will still need to comply with that. Changes. One of the unique things about the government is they can unilaterally direct changes in the scope of the work. And the contractor must proceed with the change as directed, even if the parties haven't agreed on any sort of price adjustment. The government all of a sudden wants their widget red instead of blue, you have to make it red. If it's twice as expensive to make it red, you then have to work out the price after the fact with the government. Not in commercial item prime contracts. Changes need to be mutually agreed upon between the parties. It's one of the paragraphs in FAR 52.212-4. So what do you do as a commercial item subcontractor if your prime contractor has a non-commercial item prime contract? You know that they need to accept unilateral changes by the government, but traditionally you're not required to accept unilateral changes from your customer. What we recommend is let's split the baby. Let's agree, hey, I know, customer, that when the government tells you that we need to make this change from blue to red, that you need to accept it. And so we'll accept it, and we'll get to get a cost increase just like you get to get a cost increase. However, if you, customer, just decide you want to go from blue to red on a whim, or you want to make that change on your own and it's not really a government-directed change, we need to mutually agree upon it before that change is made. So that's typically how we split the baby. Intellectual property protection. I said one of the things that make contractors reluctant to do business with the government is the government's right in intellectual property, but there's beneficial rules for commercial item contractors. There's, first of all, a presumption that technical data and computer software were developed exclusively at private expense, and there are some exceptions to that for some DoD acquisitions of major weapon systems. There's relaxed marking requirements, and there's also the ability to negotiate standard commercial licenses. So it's a huge benefit in that area. And then small business subcontracting plans. Keep in mind this exemption is only for commercial item subcontracts. So the requirement applies to commercial item prime contracts, but there's an exemption for commercial item subcontracts per paragraph J of FAR Clause 52.219-9. And I see that clause is in reference there. So again, it's FAR 52.219-9. And what a small business subcontracting plan does is it's basically the contractor's plan to use small businesses and various categories of small businesses in their contracts. They have to show the government that they are complying with it, their good faith efforts to increase small business participation, and there's requirements to report periodically throughout the year on their actual awards as compared to their goals. So in sum, the government has a stated preference to purchase commercial items whenever possible and have commercial items incorporated into non-commercial item deliverables. When selling a commercial item to the government or a higher tier contractor, they need to be prepared to justify their product meets the definition of a commercial item in FAR 2.101. Make sure that the contract terms are consistent with the FAR's preferential treatment, and you need to recognize as a clause that the customer must or should flow down. If you are buying a commercial item, so now you're the customer, you need to enlist the help of the supplier to justify the good or service as a commercial item. They know their product best. They know the market the best because they're in it. They're the ones who are best positioned to give you the information you need to show that it is of a type that is offered for sale or sold to the general public for non-governmental purposes. So if you need CLE credit, you need to enter the code in the box below and hit submit. So here are the codes, and I will read them slowly. It is 5159Z. Again, it is 5159Z. I'm going to give everyone a chance to do it. I'm going to read it one more time. One more time, it's 5159Z. And at this time, I'm going to answer a few questions. One question was, do governmental entities that we're talking about today include state, local, or municipal? I'm just talking about federal government today, and I apologize if I did not make that clear up front. In terms of another question, is the government subject to the UCC Battle of the Forms when a subcontractor can accept an order with acknowledgement that their own terms and conditions apply? Typically does not, government is not subject to the Battle of Forms, and there's an order of precedence clause in the government contracts. It is not something that you are likely to win as a contractor. I just had a question too about the DFAR clauses on protecting defense information and cyber reporting applicable to commercial item contracting. Yes, that's one of the more recent Department of Defense clauses that do not exempt commercial item contractors. So I will answer more questions at the end as time permits, but we will continue on for now. So commercial item contracts, as I mentioned earlier, traditionally are fixed price. One of the benefits as a contractor in getting a commercial item contract is you do not need to disclose all of your cost and profit information to the government. Well, why is that? Because if you have a fixed price contract, the government needs to conduct what's called a price analysis to determine if your price is fair and reasonable. So regardless of whether or not you're selling a commercial item, before the government pays for that item, they still need to determine, is that price fair and reasonable? The price analysis needs to be performed in accordance with FAR 15.404-1B. And what that says is that a price analysis does not include an analysis of the contractor's separate cost elements or proposed profit. As I mentioned earlier, for commercial item goods, the price analysis is a separate determination, and it's conducted independently of the commercial item determination. First, the government has to determine, is this a commercial item? If the answer is yes, they then need to determine the price is fair and reasonable. For services, again, if it's in that paragraph 6 definition, it's conflated into one. In order to qualify as a commercial item service, the services must be sold at catalog or market prices. The FAR lists a host of price analysis techniques, and it's in kind of descending order of precedence. So the first few are the preferred approach, and then it goes on from there. So the obvious price analysis technique is comparison of proposed prices received in response to the solicitation. So that's adequate price competition. If you submit a competitive bid and you get 3 bids back, it's assumed the price is fair and reasonable. However, in fiscal year 2014, the Department of Defense awarded about $119 billion, 42% of its contract obligations on non-competitive contracts. So those are contracts where they could not conduct a price analysis based on adequate price competition. The second one to look at is a comparison of the proposed prices that the government will pay based on your proposal to historical prices paid, whether by the government or other than the government for the same or similar items. This part of the FAR specifically goes on to say that that is sufficient even if you are selling a commercial item or even an of a type commercial item. So sometimes I have folks who say, well, wait a second, if you're selling me a commercial item, you need to show me commercial prices to justify your price as fair and reasonable. And I point to this part of the FAR that says, no, if we've previously sold this to the government or to another customer for government purposes, those prices are sufficient to show that the price is fair and reasonable. Those are what you should be looking at as a comparison and can look at. I don't need to take you to my commercial sales prices. The government's in the process of developing a prices paid tool to provide the government personnel with better access to prices across agencies and departments and under different contracts to really smooth out this process and not rely so much on the customer or the contractor providing the data themselves. Right now, that prices paid tool, it's still in development. I just visited it yesterday. And right now it only has prices paid for office supplies, domestic delivery services, GSA, GWACs, and wireless goods. So it really needs a little bit of work, I think, to be valid, but it's a good start. I have on this next slide some other price analysis techniques. The government needs to compare it to its independent cost estimate, proposed prices that are obtained through market research for the same or similar items. Really, it's up looking at other people's published price lists, things of that nature. If you notice, the very last thing on this list is the analysis of data other than certified cost or pricing data. If there is no other way to get the government or your customer comfortable that your price is fair and reasonable, then sometimes what you have to do is resort to providing them with some data other than certified cost or pricing data. What is this? Well, what I typically go to, it's pricing data. Maybe it's a breakdown of your product, not by cost and profit, but by price. What are the price of the major components? What are the price of transportation? Break it out in terms of price so that you're not disclosing your profit, your overhead, and all your cost elements, but the contractor can still, the government or your customer can still see generally, is that a fair and reasonable price to pay for those types of components, transportation, et cetera. In terms of the National Defense Authorization Act for fiscal year 2013, Section 831 required the government to issue guidance on the use of the government's authority to require that submission of other than certified cost or pricing data and determine whether information on the prices at which same or similar items have previously been sold is adequate for evaluating the reasonableness of price, and make sure that no additional cost information is required unless it's really necessary. So this is, again, a beneficial step for contractors to ensure that the government isn't just defaulting to the easy thing, the thing they're comfortable with, the thing that they like to see, which is your cost and pricing data. In December 2014, DCMA, Defense Contract Management Agency, announced that they're hiring and training roughly 50 full-time commercial pricing experts based in St. Petersburg, Florida. And what they are going to do are they are going to make recommendations to contracting officers regarding whether something qualifies as a commercial item and whether the proposed pricing is fair and reasonable. This is just a recommending group. The contracting officers are still the ones who are going to make the final call on whether a good or service qualifies as a commercial item. But we have seen a lot of even higher tier contractors referring matters to DCMA for commercial item determinations. In February 2015, Department of Defense issued some guidance in response to the fiscal year 2013 NDAA requirements, basically as a process for commercial item determinations, which, as I said earlier, sometimes took a really long time. The contracting officers should have a goal of making a commercial item determination within 10 business days after assembling all of the support data, either from the contractor or other sources. And the key consideration is whether the government's paying a fair and reasonable price. They said for commercial items, there's a preference to use market-based pricing. And if that's not available, they may use cost-based analysis to determine price reasonableness. And if there's minimal or no sales history of the government, the contractor really needs to provide information on why the price is fair and reasonable. And the Department of Defense's thought is, well, the contractor's in the best position to give us that information. The standard they were looking at for the contract officer is whether a reasonable businessman or woman reviewing the data will conclude that it's sufficient to demonstrate the taxpayers are paying a fair and reasonable price for the item. Well, what does that mean? What kind of a standard is that? A reasonable businessman or woman? Is taxpayers paying enough? It doesn't really give you a good standard there. But the DCMA Cost and Pricing Center is going to help provide some more guidance and standards in that rule. As a result, the Department of Defense issued a proposed rule that really gave a definition of market-based pricing and what data to look at. And basically, they define market-based pricing so narrowly as pricing that results when non-governmental buyers drive the price in a commercial market. And that's when non-governmental buyers account for 50% or more of sales by volume of a particular item. If that's the case, there's a strong likelihood that the pricing is market-based. Well, wait a second. We just thought the definition of commercial item said it just had to have been offered for sale, lease, or license to the general public, and now it has to be 50% or more sold to the public. That's a problem here. This is really a narrowing of the commercial item definition. And so I'm going to go through these slides, and you can read through them a little bit closer. But the good news here is, yay, Department of Defense withdrew this proposed rule on December 7th of 2015. So that's the good news following my in-person seminar in October. Department of Defense also opened a new DFAR case to implement the various 2016 NDAA provisions I mentioned herein, as well as the fiscal year 2013 NDAA provision we just mentioned. Also in April of 2015, DoD issued Better Buying Power 3.0, and some of the key themes in that document are based on our need to excel and improve our technological innovation. Our technological superiority is at risk, it said. Innovation comes from government labs, nonprofit research institutions, defense contractors, and increasingly the commercial sector and overseas. So that we need to remove barriers to commercial technology utilization and really improve access to DoD commercial item technologies. And we see that in the NDAA provisions from 2016. So it recognized that if DoD wants to gain access to these innovative cutting-edge technologies, they need to eliminate some of the barriers to using this. And so some of those increased requirements on commercial item contractors have become a barrier. They also wanted more focus on commercial item determinations. And so again, this is where we see the DoD focusing more on training and guidance and putting more manpower behind commercial item determinations. However, Better Buying Power was a little inconsistent. It also said that they're going to develop a legislative proposal to revise the definition of the commercial item to take out items and services that are just offered for sale, lease, or license to the government. Well, okay, well that's inconsistent. In one hand, you are trying to expand commercial sales, and then you're narrowing the definition. And DoD is struggling with having it both ways. In one other important NDAA provision from fiscal year 2016 is Section 852 that basically says that D&D has increased authority to purchase a major weapon system or a component as a commercial item without a price reasonableness determination if the Secretary of Defense has determined the system is a commercial item and it's necessary for national security. If a price analysis is required before requiring cost or pricing data, the Department of Defense must accept available information about prices for the same or similar items sold under different terms and conditions, or on related products or services, or alternative solutions or approaches, or other relevant information. So this really increases the scope of information available to the government to determine a price is fair and reasonable. Also, Section 853 of the NDAA requires a contracting officer to consider evidence presented by an offeror of recent purchase prices paid by the government for the same or similar items in establishing price reasonableness. Again, this is already in the FAR. We already talked about it as part of the price analysis, but the government really doesn't like to look at their prior prices paid by the government. They've always focused on prior commercial sales to justify price reasonableness for commercial items. And here it's just solidifying the point that the contracting officer can look at prior government prices as a reference point. In sum, the Department of Defense are struggling with the concept of commercial item contracting. On the one hand, especially in the IT sector, they want to encourage more commercial companies out there to do business with the federal government. At the same time, they feel like unless they're getting certified cost or pricing data, how do they really know the price is fair and reasonable? Are they really protecting those taxpayer dollars? I see these provisions of the NDAA for fiscal year 2016 as a real positive sign that recognizes that commercial item contractors are important to the Department of Defense, and they need to make sure that they really protect the sanctity of FAR Part 12 commercial item contracting if they want to continue to do business with these commercial contractors. So next I'm going to talk about opportunities available in GSA multiple award schedule contracting. GSA schedule contracts are commercial item contracts, which is why they are lumped into the discussion here today. The GSA Schedule Contract basically provides the government agencies, federal government agencies, and state and local with the ability to purchase commonly used commercial items and services easily and inexpensively. There's currently about 40 different schedules, over 11 million different types of goods and services offered for sale from over 15,000 vendors. Sales under these contracts exceed $35 billion annually. There's also a federal supply schedule program conducted by the VA, Department of Veterans Affairs, that is very similar to the GSA program. I'm not going to talk about them both today because we don't have enough time, but a lot of the same GSA clauses are in those VA contracts. What does the GSA Schedule Contract do? It's basically a government catalog. It's a hunting license. You could celebrate getting your GSA contract, but it really means you have nothing until you actually get orders under it. It's just basically a blanket contract that allows the government to issue orders. I have on the next two slides, the GSA Schedule Contracts are out there, so you could take a look at it and see, are the goods or services that you sell something that would fall within one of these schedules. Well, as a first step in the schedule process, if you're potentially interested in getting your goods and services out there, you should research the schedule. So take a look at those on the prior slides, go to gsa.gov, see what types of products and services are offered under those schedules. You also want to look at what are your competitors doing. One of the things with GSA and these schedules is price lists are publicly available. So if you go to GSA Advantage, so that's one word, gsaadvantage.gov, you can search for different contractors, different products, different schedules, and look at your competitors' price list. Look at what goods and services they have out there, look at their prices, see what it is the government's buying on these schedule contracts. If you decide it's something you might want to pursue, you should take a look at the solicitation. And those are available on the Federal Business Opportunities website at www.fbo.gov. These solicitations are continuously updated, and they're always pending. We call them evergreen. They don't have a proposal deadline or due date. They do get refreshed periodically to add new clauses and update clauses, but there isn't a set deadline to submit proposals. Each solicitation segmented into various special item numbers, so when you look at them, you'll want to see which special item number does your good or service fall under, and make sure that you are looking at the right schedule. So the first step in your proposal process is, or I don't know if it's the first, one of the steps, is to complete the commercial sales practice chart that's a part of each of these solicitations. And what this is the government wants to know what are your commercial sales practices, what are your pricing, your discounting practices. This is all customers for the goods or services you're going to propose to sell to the government, any other discounts, concessions, volume discounts, prices, rebates, whatever you want to call it, anything that you have in terms of what you sell commercially and what you're going to be selling to the government in terms of pricing. You're going to identify which is your most favored customer or potentially category customers, who gets your best price. And you want to make sure that all this information, you want to err on the side, again, of disclosure, and that all of your pricing is in there from the low to the high. Doesn't mean that when you identify your most favorite customer that that's the pricing the government's going to get. Of course, it's the pricing the government's going to want to get, but it's a negotiation standpoint. And so the key, though, is you want to disclose everything, because if the government later audits and finds out that you had some lower prices or additional discounts or concessions you did not disclose to the government, that's when you have a big headache. It's used, why does the GSA get this? Well, this is how they negotiate fair and reasonable prices. Again, it's not cost information, it's not profit information, it's prices of other commercial sales, and as well as other government sales. It gives the contractor the opportunity to distinguish sales. So like I said, you have to identify the customer who gets the best price or category of customers. But it doesn't necessarily mean that that needs to be the price of the government. So it's your opportunity to say, government, I know this looks like the best price and probably you think you're going to want to get, but you really fall within this category of customer, and here's why. Maybe there's some things that this other customer does that we don't have to do for them that we're going to have to do for you, government, and somehow distinguish it. You need to update it as information changes, and no one size fits all. It's difficult to complete. It takes a lot of thought and time, and needs to really be thought through carefully. Failure to accurately disclose information in your CSP could result in a price adjustment. GSA can perform a post-award audit to determine whether that information is current, accurate, and complete. Again, there's a certification there that what you're providing is current, accurate, and complete. The government can reduce the price of the contract or terminate the contract if they find that the contractor did not provide all required information, if the information is outdated, inaccurate, or incomplete, or if there are changes to the pricing and discounts made after the submission of information but more than 14 days prior to completion of negotiations. So if you submit all this information with your proposal, it needs to be updated if it changes prior to actually getting the contract award and negotiating the final price. There's also significant liability because once the government comes in and audits, which they could do for up to 2 years after submission of the information, they could, if they find stuff that you didn't disclose, it could potentially move from an audit to an investigation by the Office of Inspector General or Department of Justice, and there could be civil or criminal liability. So it's really important to get that right. After you submit your CSP, a GSA price negotiator is going to contact you, and they'll seek to get your best price. They're probably going to want to go to that customer that's getting the lowest price. And that's your opportunity to distinguish those sales from government sales and really identify who is going to be our tracking customer. And that's called the basis of award customer. That's going to be the one that is going to be the comparison for GSA purposes. So again, you want to be prepared to identify why should GSA not get the best price. Is it a difference between direct sales versus a sale to a dealer or distributor? After you've concluded your negotiations with GSA, one of the things contractors really fail to do is to update their CSP to really identify who is it that is that basis of award customer chosen by GSA. This pre-award process takes usually about 90 to 120 days, sometimes shorter, sometimes longer, depending on how many goods and services you're trying to get on the scheduled contract and that contracting officer's availability. After GSA evaluation and negotiation and they accept your offer, you'll get a contract award. And again, what do you get? You get an indefinite delivery, indefinite quantity, known as an IDIQ contract. It has a base term of 5 years and 3 5-year option periods. So these contracts, once awarded, can go on for 20 years. Agencies issue task or delivery orders. So although this is a contract with GSA, all federal government agencies could order off of it. And as I mentioned earlier, some state and local government agencies can as well. There's not an agency publication requirement, so these don't have to be on the Federal Business Opportunities website. The purpose of these negotiations is that GSA has found your price to be fair and reasonable, so you don't need to go through that process each time. There is a fair opportunity to be considered standard among schedule holders. The orders are issued by those individual agency contracting officers. So for example, if you get an order from the Department of Defense, you might see some additional FAR, DFAR clauses in there that wouldn't be in your GSA contract because GSA doesn't have DFAR clauses in it. What are some of the key clauses, though, and compliance requirements in that GSA contract, which I just told you all the benefits of getting one. It gets you access that you don't have to go through this fair and reasonable pricing rigmarole each time. Again, it's only for commercial items, so if your good or service is on there, it's presumed to be a commercial item. Why should you maybe think twice or be very cautious before going into this? And the first is the price reduction clause. This requires the contractor to notify the government if during contract performance it reduces its price list or otherwise gives some sort of discount or concession to the basis of award customer. As I said earlier, you have your CSP, and you're going to negotiate as part of the contract who this basis of award customer is. It does not necessarily need to be the customer that you give the lowest price to. It's whatever the comparison is to the vis-a-vis the government. You also don't need to give the government the same price as the basis of award customer. What this requires is that you keep the same relationship throughout contract award, and I have an example here. If, let's say, you give a discount to the basis of award customer, this is entity X at the time of award, and that's 15%, okay? Post-award, the discount to the basis of award customer increases to 20%. You need to disclose that to the government, and now you need to give an increased discount to the government. If you were initially not giving the government any discount, now the government needs to, whatever discount you're giving needs to increase by 5%, whatever discount you were initially given to the government. That price reduction that you need to tell the government about and extend to them, it goes from the effective date of that commercial sale where you gave that better discount throughout the rest of the contract. So there is a look-back period. There are some exceptions to the price reduction clause, and that's if you have a sale to a commercial customer with specified delivery in excess of the maximum order threshold. Each GSA contract has a maximum order threshold that is really dependent on the goods or services provided. If it's over that threshold, then it doesn't apply. It doesn't apply to other federal agencies. You can always give the federal government a better price. That's never a problem. They don't complain about that. If you give a state or local government a better price under a schedule contract, under the GSA contract, again, that's not a problem. And they do have an exception for potentially some additional discounts that are caused by an error in quotation or billing. So if you guys make some sort of calculation error and end up giving a better discount to a commercial customer and then realize it, notify the government, put a memo to the file, memo the government, hey, you know, it's really, it might look like a price reduction if you ever audited, but it's really not, and here's why. We miscalculated, and we wanted to let you know about it. It's always better to get ahead of it and let the government know about it now versus them finding it in an audit after the fact. Maybe it's an audit 3-4 years after the fact. Who knows if that employee who made the error is still there, and no one really knows why it looks like they got that better price, and the government may insist on a price reduction 4 years back to that date. You can always provide the federal government with a voluntary price reduction, so you could always give them a better price. So how do you avoid triggering the price reduction clause? First of all, the government will, GSA will often push in terms of the category of customer to have as the basis of award customer. They want all commercial customers. That's your basis. Well, that's really hard to manage, right? To make sure that you're not giving any commercial customer a better price than whatever price you're proposing the government or the agreed upon relationship in terms of pricing. So the best way to avoid triggering it is to make sure that you are as much as possible narrowly defining that basis of award customer. You also want to make sure that basis of award customer and the discount that they receive is clearly identified in the schedule contract. I can't tell you how many times a client comes to me with a question about their schedule contract, and I say, give me the contract. And it actually takes usually 4 or 5 emails before I actually get the page that tells me who the basis of award customer is, and sometimes it's not well defined. You want to have adequate policies and procedures in place to ensure compliance. And we've had clients who say, well, we educated the people who do the government contract stuff. That's actually not the people that you have to educate mostly. It's the commercial side. We all know sales folks. Sales folks want to make the deal. They want to make the sale. They'll agree to whatever concessions they need to in the moment to make that sale, without realizing that if they make that concession on the commercial side, the impact it's going to have on the government side under these contracts. So it's very important that commercial folks, especially on the sales side, are trained on these requirements. Also, implement internal controls to track sales and signal red flags when a sale may violate the price reduction clause. We all deal in the digital age. It should be fairly simple to have some sort of alert or trigger in your system where if someone's trying to get a steeper discount, it's not allowed to go through without certain approvals. Promptly notify the contracting officer of any price reduction, even if it's the result of a quotation or billing error. Again, just because you notify the government doesn't mean they're going to require a corresponding price reduction. Economic price adjustment. So these prices in your schedule are set at the outset, but you are allowed to ask for economic price adjustment increases. You have to wait for the first 12 months to pass, and you can't have more than 3 increases for each 12-month period. Although I have to say each federal supply schedule is a little different in this regard. There might be some nuances here, but each clause will tell you that there's a certain amount of increases you can't have in a certain amount of time. So in terms of the specified percentage, there's usually a specified percentage it can't exceed. Sometimes it's 4% or something like that. The government can still try to negotiate a decreased price or request that the item be removed from the schedule. And then if the government does agree to an economic price adjustment, you want to make sure that your schedule contract is formally modified with an EMOD, a modification reflecting that. And then also you have to update your schedule price list. As I said earlier, all contractors who have these schedule contracts have to have a price list that's current and accurate on GSA Advantage. So you want to make sure that's always kept up to date. Industrial funding fee. Well, GSA does not do this out of the goodness of their heart. They do this because they get a portion of every sale. So this is the fee that's paid to GSA to cover the administrative and program costs of administrating these schedule contracts. The IFF is incorporated into the contractor's price, and it currently stands at 0.75%. The contractor has to make sure that they are tracking all sales that are under their GSA contract so that they know which sales they need to pay this IFF on. So on a quarterly basis, contractors need to report how much they need to pay in terms of the IFF and remit the payment. These reports and payments need to be submitted within 30 days after the completion of each reporting quarter. And if you fail to pay it, it's a debt, and you'll get interest that will start to accrue. The government, in terms of all their audits, but including the IFF audit, they come in and audit your compliance with the price reduction clause, your compliance with the IFF reporting requirements. Sometimes they do it annually. Sometimes they do it right before your 5-year renewal period is coming up. And it's usually performed during what's called a contractor assistance visit. So they don't really call it an audit, but that is really what it is. If you have any problems or inconsistencies in your reporting and your tracking, you should expect some follow-up audits. Some of the consequences of failing your audit or not having sufficient policies and procedures in place to ensure compliance with the price reduction clause and remitting payments to the IFF, it includes termination for default and withholding or setting off of payments. So it's an important clause to comply with. The other thing, we could probably do also a whole day seminar on the Trade Agreements Act, but I want to mention that all of the goods and services on these scheduled contracts are subject to the Trade Agreements Act. There's been a lot of litigation in recent years, and well, I say litigation, more investigations and heavy penalties and fines to government contractors for failing to comply with the Trade Agreements Act, in particular with respect to GSA multiple award schedule contracts. So the Trade Agreements Act mandates that the government purchase products of U.S. or designated countries. TAA prohibits the government from acquiring end products from non-designated countries. So unless in your proposal to the government you identify that you are going to provide a product that is substantially transformed in a non-designated country, and the government says it's not available from any other source, so we're going to approve that we're going to buy it from you, unless that's the case, you need to provide a product that is substantially transformed in the U.S. or a designated country. Some of the countries that are not designated, Brazil, China, Thailand, or India. A lot of products are manufactured in those countries. There's no price add-on, so it's not in the Buy American Act. It's just a pricing preference law. This is different. It's a yes or no, and every contract has a Trade Agreements Act certificate. If you're not filling out the Trade Agreements Act certificate, you are certifying that what you are providing will comply with the Trade Agreements Act. Penalties for noncompliance. Potential penalties for failing to comply with the schedule's terms and conditions, a price adjustment, a termination for default or convenience, suspension, debarment. I mentioned a few times False Claims Act liability, False Statements Act liability, other fraud statutes, and criminal prosecution. So what do you do? Well, developing and implementing an effective compliance program is critically important to avoid these penalties. All GSA schedule contracts, although they don't really have a dollar value to them, I mean, technically they have a $2,500 minimum value. They are cancelable upon 30 days notice by any party. But even though they don't technically have a value to them, they all include FAR Clause 52.203-13, and that is the Contractor Code of Business Ethics and Compliance Clause. In terms of that clause, it requires commercial item contractors to have a code of ethics and business conduct to make it available to employees. Although not required for commercial item contractors, they are encouraged to have business awareness and ethics programs and other types of compliance measures. So that is a clause to take a look at and to make sure you're complying with it, and gives you some suggestions in terms of compliance. In terms of a proposed rule that's out there, the GSA has a transactional data proposed rule, and that was issued in March 4th of 2015. There's been a lot of concern throughout GSA and contractors about the price reduction clause. It's onerous to comply with. It creates a lot of problems. I think it creates a lot of liability for contractors and a lot of audit responsibility for the government. So what they looked at, and this is only for GSA Federal Supply Schedule contracts, and again, this is a proposed rule, they want to be able to share prices previously paid by agencies throughout the government and really improve the government's ability to conduct a meaningful price analysis. So what this would do, it would replace the price reduction clause with a clause that provides the government with the ability to request from the contractor a price reduction at any time during the contract period, and also provides the contractor can voluntarily offer a government-wide price reduction at any time. Basically what this does is the government would maintain the right throughout contract performance to ask a contractor for updates to their CSP when commercial benchmarks or other available data on commercial pricing is insufficient. So what does this really do for contractors? Basically what it does is the contractors have to, at any time, whenever the government asks about it, to give them information about their commercial sales practices. In addition, it imposes on contractors the requirement to collect and electronically report transactional data to GSA on a monthly basis regarding their sales to the federal government. Again, not just for GSA contracts, all their sales to the federal government, to look at prices paid across government. So it's going from kind of a vertical look at what is it that you're selling from, to all these customers, just to kind of a horizontal across the government. What are these prices, both under GSA contracts and outside of it? There's a mandatory pilot program for certain cost items, and the pilot program I have listed there, the schedules that will be included in that pilot program. And it's likely going to force contractors to sell products to GSA at the lowest price. And you know what? Lowest price doesn't always mean best value for the government. So there's a significant administrative and compliance burden. There's a lot of pushback from contractors on this. The monthly reports have a lot of information in it that you have to include. You have to include the contract or BPA number, the order number, if applicable, the description of the deliverable manufacturer, the manufacturer part number, unit of measure, so on and so forth. I mean, the GSA estimated it would take about 6 hours to set up and about a half hour per month. The Coalition of Government Procurement thought it would take 232 hours to set up for small businesses and 1,192 hours for large businesses and 38 hours per month for small businesses to keep it up, and 68 hours per month for large and medium contractors. Not to mention, this data is already available to the government, right? Federal agencies can report information through GSA Advantage. They can look at pricing across contractors. They also have the Federal Procurement Data System that shows where prices that the government pays for other goods and services through non-GSA contracts. That's where they can see contracts awarded to contractors and what the price is paid. So it seems like a very burdensome rule for little to no benefit to the government. Okay, so for the next CLE code, if for those of you who are still listening and awake, it is F as in Frank, Z as in zebra, B as in bear, C as in cat, R as in rabbit. So again, it is F as in Frank, Z as in zebra, B as in bear, C as in cat, R as in rabbit. And I'm going to give it 1 second, and then I'll repeat it again as I look through some of these questions. So one more time, it's F as in Frank, Z as in zebra, B as in bear, C as in cat, R as in rabbit. And now I'm going to take a few minutes to answer some of these questions that have come in. So the first question is, can a prime contractor request from a Tier 1 supplier their rates in a solicitation if the TINA threshold is not exceeded? So currently the TINA threshold is $750,000. Can you ask for it? Yeah. You could always ask for whatever you want. Is the Tier 1 supplier required to provide it? No, they are not required to provide you with certified cost or pricing data under TINA if their subcontract is below the TINA threshold. That said, if you cannot justify their price as fair and reasonable through any other means, it is okay under the price analysis methodology in the FAR to look at data other than certified cost or pricing data. So what is that? Well, it's basically you start with pricing data. You could end up getting some cost data. They don't need to certify it. They don't need to give it to you in a certain format, and they don't need to disclose every single cost or pricing data that might be relevant. So it's a subset of that data. The next question is, does a customer need to formally accept or reject a commercial item justification? That's a good question because that comes up often as to whose job is it to really determine is there a commercial item that a supplier is selling? Is it a commercial item? Is it not? Whose determination is that? It is up to the government in the first instance when they're issuing a solicitation as to whether or not it's a commercial item solicitation. As I showed you earlier, there's that certain standard form that it's on, and the government makes that determination before they issue their solicitation. If you think that it's issued as a non-commercial item solicitation, it should have been commercial item, you could do a pre-award protest. You can email the contracting officer if it's during a Q&A period. You could definitely push that issue with the contracting officer. With respect to subcontracts, it's up to the higher tiered contractor to determine whether or not the good is a commercial item. Often they will ask the supplier to do a commercial item justification because the supplier is in the best position to give the information that's required for that, and then it helps kind of put it in their file. So if the government ever audits, they could say, we did our determination, we did our due diligence to determine it's a commercial item. But it's really up to the customer to decide. Again, for those who did not get that code, it's FZBCR. In terms of the other questions, question is, if you're doing a FAR Part 15 contract, but you're providing goods that are traditionally commercial items, how do you best protect yourself from government overreach if they want cost or pricing data for the commercial items? Again, if you are entering into a FAR Part 15 prime contract with the government, you could be subject to certified cost or pricing data if it's not competitively awarded or subject to some other exemption. That determination is made by the government at the solicitation phase. So if you've already issued your proposal and you've received the contract, you're kind of out of luck there. It's not government overreach. The government just determined it's not a commercial item. The time to raise that is through a pre-award protest. Another interesting question, which is really a good one, if parts are ITAR or EAR controlled, does that have any impact on whether they can be deemed commercial? I didn't say this at the outset of the presentation, but a lot of my folks who are very heavy into ITAR and EAR, when I start talking about commercial item, they go to commerciality and commercial as it has meaning under the ITAR and EAR. And I'll tell you right now, they're completely separate determinations. You can have commercial items under the FAR that are subject to ITAR. It really is independent discussion, independent determination. So as you think about commercial item for commercial item contracts under FAR Part 12, you'll have to clear your mind of what is commercial or non-commercial under the ITAR or EAR. Okay. So earlier when I had said we were only talking about federal government contracts, there was a clarification on the question. And the question is, when you're trying to show that something is a commercial item, can the contractor point to sales to buyers as non-governmental sales, to state and local buyers to support the non-governmental sales to support a commercial item conclusion? The answer is yes, they can, because I have to look back at the non-governmental definition a little bit closer, but usually if you're talking about those types of sales, those would be a good example, but you would usually also like to have some purely commercial customers in there as well. I think I've answered most of the questions there. And if I didn't get to your question, feel free to shoot me an email afterwards. I thank you to you all who stayed in this for me for the long haul and listened to the presentation today. We will be having a in-person presentation in October. If you're signed up for this, you will get an email invitation to that. We'll probably be talking about intellectual property protection, DCAA audits, and False Claims Act liability. There's a lot of movement in all those areas. So as a reminder, our web conference survey will automatically pop up. So if you would please take our survey, I really appreciate your feedback. I know webinars are not ideal in terms of personal interaction, but I think it's the best bet to sometimes reach the masses. So I appreciate your time today. Thank you for joining. Bye-bye.